We are on the record. This is the beginning of video number 1 of the deposition of Philip Ertl. This is in the matter of Professional Focus Publications, LLC versus Wauwatosa School District et al. This case is pending in the Circuit Court of Milwaukee County, and the case number is 15CV004750. This deposition is taking place at Lindner and Marsack, SC, located at 411 East Wisconsin Avenue, Suite 1800 in Milwaukee, Wisconsin. Today's date is February 3rd, 2016, and the time is 2:37 p.m. My name is Janelle Clovis with Riker & Lyle Legal Video Service, and the court reporter today is Peggy Mitchell with Brown & Jones Reporting. We'll have counsel identify themselves for the record, and then the court reporter will swear in the witness.
Attorney Eric Kruger appears on behalf of the petitioner, Professional Focus Publications, LLC.
Attorney Christopher Hansen of Lindner and Marsack appears on behalf of the respondents, Dr. Philip Ertl and Wauwatosa School District.
Okay, would you raise your right hand? I'll swear you in. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
On October 16th, you testified that you had no recollection of seeing that document before that date, correct?
Correct.
Okay. And you also testified that you couldn't remember if Mr. Dan Chanen, C-H-A-N-E-N, ever discussed that document with you.
Correct.
Okay. Now, you were present for Mr. Chanen's deposition on December 2nd, 2015, correct?
Yes.
And at that time, Mr. Chanen testified that he did recall seeing that timeline, correct?
I believe he did, yes.
Okay. He also confirmed that he had possession of that document at his deposition. At his deposition, Mr. Chanen testified that he had possession of that timeline during his tenure as the HR director for the school district.
Yeah, I don't remember if he, I don't remember if he said he had it or not.
Okay. Well, I represent to you that that's his testimony. Mr. Chanen could not recall physically passing that document along to you, correct?
Correct.
But Mr. Chanen did testify that it would have been appropriate for him to discuss that document with you, and that it would have been inappropriate for him not to discuss it with you, correct?
I'll object that that misstates Mr. Chan's testimony, but you can answer.
Yeah, I'm not sure he said that. I think there's, I'll just leave it at, I'm not sure how he responded to that.
Having sat through Mr. Chanen's deposition, does his testimony refresh your memory whether you had seen that timeline before October 16, 2015?
No, it didn't.
Okay. And having sat through Mr. Chanen's deposition, does that refresh your memory whether you were aware of that timeline before October 16, 2015?
No.
So it's still your testimony today that the first time you saw that document was October 16, 2015 at your first deposition?
As far as I can remember, yes.
Okay. Mr. Ertl, you testified that you're the chief operating officer of the school district, correct? That was your testimony back on October 16.
Sure, yes.
And you testified that you're the chief enforcer of the district's policies and guidelines, correct?
Yes.
And you testified that, to put it this way, the buck stops with you when it comes to keeping track of district records, correct?
Yes.
What, if any, investigation has the district commenced since October 16, 2015 regarding the allegations in the timeline?
It hasn't commenced any.
And why not?
I don't think because of a document being produced like this would facilitate any kind of allegation or any kind of investigation. their allegations. Like I said, if it was given to Mr. Chanin and others as well, I expect that that would have been carried out, but nothing has come to my attention to make me believe, after sitting through the depositions with all the administrators, that what they're doing is inappropriate or they haven't handled complaints appropriately.
So regardless of whether that allegation is true or false, don't you think that it would be beneficial to go back and determine whether the district's policies and guidelines were implemented properly in respect to that incident?
I have no reason to believe that policies and guidelines weren't followed.
All right. Dr. Ertl, you testified on October 16, 2015 that you could not recall having a meeting with parents or coaches in 2014 regarding a bullying complaint that they had filed, right?
Right.
And you were present for Mr. Jeff Kiernan, K-E-R-A-N-E-N, his deposition that we took on December 2nd of
Yes.
last year, correct? Mr. Kiernan testified that you were present for a meeting with parents on December 16, 2014, and that you in fact got a document, a copy of the complaint that they had filed, correct?
Yes.
And based upon that testimony from Mr. Kiernan, is it still your testimony that you cannot recall that complaint?
No, I do recall it.
Let me just show you Exhibit 3. Exhibit 3 is a document that the school district produced to me on January 29, 2016. Is this the parent complaint that we're talking about now?
Yes.
Okay. Does this refresh your memory about what that complaint involved?
Yes.
Did the district have this document, this parent complaint, at all times since December 16, 2014?
Yes.
Why did the district not produce this document to me until January 29, 2016?
I guess-
Just object to the form that you can answer the question.
It's a student record, number one. Number two, it's not necessarily a bullying complaint. It references the bullying policy, but because it references a policy doesn't mean it's a bullying complaint.
So I'm just wondering again, if the parent complaint, Exhibit 3, was within the appropriate timeframes, and we specifically asked for documents that were submitted to the district under policy 5517.01. Why wasn't Exhibit 3 produced before January of this year?
Well, I'm going to
We
object
consider-
I'm going to object that it mischaracterizes Exhibit 4 and that this has already been asked and answered.
You can answer the question.
It's a student record.
Was it an oversight on your part or the district's part?
No, it's a
Objections
student
been
record.
asked and answered.
If you know, when did you make the determination that Exhibit 3 was a student record and that you would not produce it to us incident to my open records request?
I wouldn't know.
Since your testimony is that Exhibit 3 is a student record, it seems that an inference would be you didn't simply forget about that document, correct?
Correct.
So at all relevant times to this litigation, you were aware that that document existed?
I'm not sure. What do you mean all relevant times?
Well, we filed a petition for writ of mandamus.
I guess ultimately I can say that I knew it existed ever since it was given to me.
Okay, that's good enough for me. Can you tell me why you believe Exhibit 3 is a student record and not something subject to the open records law?
Because it relates to information that's individually identifiable as an individual student. And there's, I don't have the entire statute in front of me about what constitutes a student record.
Can you point out to me on Exhibit 3 where there's information relating to the individual student?
I think it has it with the parents. It talks about behavior of students, their reaction, what they've done.
Are those parents identified on this document?
Yes.
Where?
The coaches, Phil and I.
Well,
I think with the number of, well,
Well,
I don't know that that
Exhibit 3
relates.
has been redacted.
right.
Right. And it's been produced subject to the discovery statutes solely for the purposes of this litigation. And I'll testify that the parent, or I won't testify, but I'll state for the record that the parents' names and the student's name has been redacted from this record to produce it pursuant to discovery.
Mr. Ertl, did you make these redactions yourself?
No,
Do you know who did?
no,
Do you know when they were made?
no.
Is the original document, if you know, redacted?
Is- Are you asking to, not that I'm aware of.
And just for my own memory, Exhibit 3 is something that was originally drafted by a parent and given to the school district, correct?
Yes,
So it didn't come into the district's possession with redactions on it.
correct.
On October 16, 2015, at your first deposition, you testified that the Bulow-Vetter firm did a special investigation involving bullying at the Washington Elementary School in 2013, correct?
I don't know verbatim what I testified, but they did do one.
And was it not your testimony that the investigation was appropriate because of the number, nature, culture, and climate of the bullying at that school?
I'll object. It seems facts, not evidence.
Yeah, again, with the word bullying, bullying is not bullying unless it's confirmed to be bullying. Alleged behavior can be alleged bullying, but yeah, it sounds similar to what I recall testifying.
Okay. Well, I represent to you that is what you testified to. On January 29th of this year, 2016, this school district produced to me the report or the two-page summary of that investigation, correct?
Right.
I'll have that marked as Exhibit 5. So what you're looking at now, Exhibit 5, it's actually a 4-page document because what I did was I stapled a 2-page sort of letter or memo that you apparently wrote to the back of it. Do you recognize each of these documents?
Yes.
Okay. Now, the district did not produce either of these things that are in Exhibit 5. That wasn't produced to me incident to my open records requests, was it?
I don't believe so.
And it was produced just last month, right?
Correct.
Why were these documents that are Exhibit 5 not produced at an earlier time?
Should have been,
Why should they have been, in your opinion?
because I think they meet the request that you had put forward.
Exhibit 3, the parent complaint. I'm just wondering if there's any other paper trail related to that document that was generated after December 16, 2014 that you're aware of.
Not that I'm aware of.
So as far as you know, the parents gave you and the district a copy of that complaint, correct?
Correct.
And that is the only document that the district has related to those allegations.
That I'm aware of.
Okay? Would you expect that there would be other documents generated after the fact?
You know, actually, there is a document after the fact, and it was my email to the parents of this November.
2015.
Maybe it was September. Sometime this past year that I responded back to them.
Okay. Anything else that comes to mind?
No.
Were there any kind of well, let me ask this question. When you got that complaint, did you do any kind of investigation into the allegations?
Personally, no.
Are you aware that anybody else in the school district investigated the allegations?
Yes.
Who did the investigation?
Athletic director,
Who's that?
Jeff Gabrielson.
Okay. Do you know what his investigation involved?
No.
And there's no paperwork related to that investigation?
Not that I'm aware of.
Okay, it's just informal fact-finding.
I don't know if it was informal or formal. I'm not sure the difference, but I know he investigated it.
Okay. But as far as you're aware, there's no written record of his investigation?
Not that I can recall.
In your email to the two parents that you testify you sent in fall 2015, was there any kind of final disposition or final findings that you related to them?
No, it was in response to another meeting I had with them this past year.
Does the parent complaint fall under any of the district's policies or guidelines in terms of, let me rephrase the question. In your experience as the superintendent of the school district and your familiarity with the district's policies and guidelines, was that parent complaint submitted to you under any particular policy or guideline that you're aware of?
Objection foundation.
No.
Okay. Just turn the page, please, of that exhibit. And isn't it the case that the drafter of this complaint specifically referenced policy 5517.01?
Yes.
And isn't it the case that the drafter of this document recommended that the school administration uphold that policy.
Yes.
So I'm not asking you if the author correctly summarized policy 5517.01, but what I am asking is, this document clearly references that policy, right?
It references a policy 5517.
So even though there's an express reference there, in your mind, this complaint still does not fall under that particular policy,
Not, if someone references a policy, doesn't mean it falls under it.
okay? What policy or guideline might this, in your opinion, this complaint fall under?
I don't know. I would have to look through the policies and guidelines to give you an answer on that.
Okay.